Welcome to our webinar on COVID-19. We're going to be talking about loan forbearance and moratoria and what lenders need to know. My name is Larry Rothenberg. I'm with the law firm of Weltman, Weinberg & Reese, and we're presenting this webinar in partnership with the Community Bankers Association of Ohio. I would like to thank Asa Bittinger and Patty Wells for their help in getting the webinar organized. And you should know that the slides that we're going to be presenting this morning will be made available to everyone after we're finished. So with that, let's move to our first slide, and we'll talk about some ground rules for today's presentation. First of all, please make sure that your phone is muted to eliminate any background noise. You should see on the right side of your screen a panel where you can type your questions, if you have any, and they will be answered at the end of the presentation. And we should be able to conclude this session well within 1 hour, including the question and answer period. Moving on. Today's agenda. Again, as I said, my name is Larry Rothenberg. I'm with the law firm of Weltman, Weinberg & Reese. I'll be talking a little bit about my firm in a moment, but today's agenda will include a discussion about the Federal CARES Law, C-A-R-E-S, as it's called. This was passed by Congress on Friday and signed by the President and is now the law. We're going to talk about how this new federal law affects mortgage servicing. We're going to talk about how to handle forbearance requests effectively with a view toward the lender's rights, the creditor's rights, and how to cover all of the bases in the forbearance agreement and in those dealings with your borrower. And we'll also talk about the foreclosure and the eviction moratorium. Let's move to the next slide. First, a little bit about my firm. Those of you who know my firm, Weltman, Weinberg & Reese, we're a national full-service creditors' rights firm, and we represent both large and small financial institutions throughout the country in real estate default matters, bankruptcy, consumer and commercial collections, litigation, and probate collections. I've been with the firm for 40 years now, and we've been representing our clients for well over 80 years as a firm. We put into the forefront of what we do strict adherence to compliance requirements, as you should, with also a view toward security standards. And also in the forefront is our clients' reputation management. That's especially important now where the pressure is on the lenders to assist borrowers and cooperate and give them accommodations as they might need it. You can look at our firm's website, weltman.com, for more information about our firm. So let's get started with the next slide. And the scene that we're in today, we're well aware borrowers are having financial uncertainty due to illness, job loss, or workplace closures. This is actually not new. Even before this COVID-19 pandemic, we've had these issues, but obviously it is exponentially greater today. We're seeing that courts are imposing stays on foreclosures and eviction. Some courts are actually closing altogether, but foreclosures and evictions in particular are pretty much coming to a standstill, but we'll talk more about that in a moment. The federal law that was passed on Friday is one example, but also state governments are imposing their own laws and orders for foreclosure and eviction moratoria. And federal and state governments are encouraging borrowers to reach out to the lenders to seek forbearance agreements for temporary payment relief. Let's move to the next slide. And we'll talk about the Federal CARES Law as it relates to mortgage loans. The Federal CARES Law is an 880-page law and it contains a section starting around page 567 that relates to mortgage servicing. It talks primarily about forbearance requirements both on 1 to 4 family residences and to multifamily dwellings, greater than 4 families. But you should know that the federal law only applies to federally backed loans. And the law defines federally backed loans as being any loan secured by a first mortgage or a subordinate mortgage, including condominiums, if, and that's a big if, it is insured, guaranteed, or securitized by the FHA, Section 255 of the National Housing Act, Housing and Community Development Act of 1992, the VA, the Department of Agriculture, Freddie Mac, or Fannie Mae. And it does not apply to any other loan. So when I'm talking about the Federal CARES Act, which I'm going to talk about for the next several minutes, you should know that the federal law only applies to those federally backed loans that fall into one of those categories. Next slide, please. First, we'll talk about the requirements for mortgages on 1 to 4 family residences. According to the law, the borrower can request a forbearance, and by forbearance, we're talking about skipping payments or making reduced payments. And the law permits the borrower to make that request as a simple request. In other words, the lender, again, if it's a federally backed mortgage, you're probably going to hear me say that about 10 times. The federal law only applies to federally backed mortgages. But if it is a federally backed mortgage, your borrower is only required to request a forbearance and affirm that they are having a financial hardship caused directly or indirectly by COVID-19. They're not required to produce any proof or any documentation or any qualifications other than making a simple request and affirming that they are experiencing a financial hardship caused by the COVID-19 pandemic. The law states that forbearance shall be granted. The word shall means must. There's no discretion on the part of the lender. If the borrower makes the request and affirms that they're experiencing a financial hardship caused by the COVID-19 pandemic, the lender is required to grant forbearance up to 180 days. That's 6 months. And the lender shall extend the forbearance for up to 180 additional days upon the borrower's request. So if they make a request today and affirm that they're experiencing a financial hardship caused by COVID-19, and they ask for up to 180 days forbearance, the lender, again, if it's only on federally backed mortgages, but the lender is required to grant that forbearance. And as that 180-day period expiration approaches, the borrower can request an additional 180 days, and the lender, again, does not have discretion and must grant that borrower's request. During the forbearance period, there can be no late charges or penalties imposed, and there can be no interest on the skipped payments or the reduced payments that are being paid during the forbearance period. Now, many of your systems might not necessarily be able to accommodate turning on and turning off the imposition of late charges or interest on those payments that are skipped or reduced. But if you've got a federally backed mortgage, you're going to have to find a way to manually or somehow make sure that your statements that are being sent to your borrowers do not include late charges or penalties or interest on those skipped payments or reduced payments during the forbearance period. To the next slide. What I just talked about was mortgages on 1 to 4 family dwellings. Now we'll see what the law says about multifamily dwellings. These are mortgages on properties for 5 or more families. There are some differences between the multifamily dwelling requirements and the 1 to 4 family dwelling requirements. But for multifamily dwellings, first of all, the borrower must be current in payments as of February 1st of 2020 in order to qualify for that mandatory forbearance, mandatory on the part of the lender. So they must be current as of February 1st. If they're past due already as of February 1st and they request forbearance and it's a federally backed mortgage, in that situation, and on a multifamily dwelling, in that situation, the lender does have discretion on whether to grant the forbearance or not. But if they're current as of February 1st and it's a federally backed mortgage on a multifamily dwelling, the lender does not have discretion and must grant the forbearance. The time frame is also different for a multifamily dwelling. If the borrower requests forbearance for a multifamily dwelling, the servicer shall provide forbearance for up to 30 days, not 180 days like the 1 to 4 family dwellings, but up to 30 days for a multifamily dwelling. And as far as the extensions, the borrower can ask for 2 additional 30-day periods. And if they do ask, then the servicer must give them those extensions, provided the borrower's request is made at least 15 days before the end of the initial period. The law states that a multifamily borrower, again, only as to federally backed mortgages, who receives forbearance from the lender may not issue a notice to a tenant to vacate due to non-payment of rent until after the forbearance. So in other words, if the borrower is being granted forbearance by the lender, the borrower's tenant is entitled to forbearance as far as their rent payments to the borrower who's their landlord. Also, here in Ohio, for example, to commence an eviction for non-payment of rent, the landlord must start with a notice to vacate the premises for not less than 3 days before they commence the eviction. Under this federal law, that 3-day notice must now be for 30 days. Let's move on. Again, I'll say it again, this is probably the 5th time. The federal law only relates to federally backed mortgage loans. The federal law does not apply to non-federally backed loans. So when there are non-federally backed loans, now you've got discretion and you can set your own policy as to whether to grant forbearance and for how long and what type of forbearance and so forth. Also, the federal law, as far as forbearance, applies to, as I said, 1 to 4 family dwellings or multifamily dwellings, but not to other kinds of properties, such as other commercial properties. In addition to the federal law, however, be alert for states enacting their own laws that may impose more stringent requirements. For example, Ohio House Bill 197, which was also just recently passed, this is actually a good thing, tolls the statute of limitations for civil cases that would otherwise expire between March 9th and July 30th. So if you were planning to file a collection lawsuit and your statute of limitations is about to expire, your statute of limitations will be extended until after July 30th. You should know that Massachusetts in particular entered an order prohibiting new collection lawsuits to be filed at all, and Massachusetts and Nevada both entered orders prohibiting outbound collection calls. So if you happen to have a borrower who resides in Massachusetts or Nevada, you can no longer make an outbound collection call to them. There are questions as to whether that order is constitutional, but the orders are on the books, so unless you want to test the constitutionality of it, you should be aware as far as your borrowers who might now reside in either of those two states. Next slide. Now we'll talk about the CARES Act's foreclosure moratorium. Again, the CARES Act only applies to federally backed mortgage loans, not to any other kind of loan. But the foreclosure moratorium as to the federally backed mortgage loans extends through May 17th of 2020. And what that means is we can no longer file a new foreclosure for you until after May 17th. And as for pending foreclosures, we can no longer file a motion for judgment. That would be a motion for default judgment or a motion for summary judgment. We also can no longer file a precipice for the issuance of an order of sale to the sheriff. And for sales that are already scheduled, those sales cannot be executed. That moratorium runs through May 17th. However, the federal law does not prohibit some other activities in pending foreclosures, such as perfecting service of the summons and other ancillary proceedings other than filing a motion for judgment or causing a sale to be scheduled or executing a sale. On the other hand, each court on its own is enacting its own policy. For example, as I said, some courts are closing altogether. Some are putting stays on foreclosure for, say, 60 days or whatever. So each court has its own requirements. Each state has its own requirements. And then we have the federal law as well. My firm is keeping track throughout the country of all the courts and all the states, as well as the federal act and the individual requirements. So we've got a full spreadsheet that's updated daily. So if you need information on any of those, please contact me and we can bring you up to date on those. The foreclosure moratorium applies, again, only to federally backed loans, but to all types of properties. So here, not only the 1 to 4 family residences and the multifamily residence, but to all types of properties, except properties that are vacant and abandoned. Now, I expect that courts are going to give us a hard time if we're trying to proceed with a property that is vacant and abandoned, if it violates the court's own policy, but we'll do the best we can to try to keep those cases moving to the extent the courts will allow. Next slide. The federal law also imposes an eviction moratorium. Once again, applicable only to properties with federally backed mortgage loans. So for landlords that are not receiving their rent payments, they will not be permitted to file an eviction until at least 120 days after the enactment of the federal act. They will also be required to serve a 30-day notice to vacate, which cannot be served until after 120 days from the enactment of the act. So here I think Congress didn't read carefully these two requirements, because the first requirement, not filing an eviction until after 120 days after the enactment of the act, is really irrelevant, because if the landlord still must serve a 30-day notice to vacate, which they cannot serve until after 120 days from the enactment of the act, which means they actually won't be able to file an eviction for at least 150 days after the enactment of the act. As a lender, you probably don't have properties where you are the landlord. You might have a few miscellaneous REO properties, perhaps, where you did enter into a landlord-tenant relationship with either the borrower or an occupant. But this eviction moratorium is important to you, even as a lender, because you have borrowers who depend on rent collections to pay their mortgage. So if they're not able to collect their rent, and if they can't even evict a non-paying tenant for such an extended time, you're going to see a wave of these borrowers asking for relief on their mortgages. These are mortgages on investment properties or other commercial property. Now, what I'm going to say next only applies to larger commercial real estate loans that are structured as non-recourse debt. So for the benefit of those that have these types of loans in their portfolio, the rest of you, please bear with me for about the next minute or two. I'm talking now about non-recourse debt, where the lender is generally looking only to the mortgaged property in case of default. So while the borrower who defaults might lose their property, the borrower and the guarantors are not personally liable for any deficiency between the value of the collateral and the amount owed on the loan. However, with non-recourse loans, the documents generally include carve-outs, where the borrower and the guarantees sign a carve-out guarantee. So in certain circumstances, they will be personally liable for up to 100% of the loan. So what are those circumstances? Something as seemingly innocuous as an email to the lender asking to skip a payment because they don't have the necessary cash flow could be a technical default that triggers the carve-out. There are other circumstances as well, such as failing to maintain and repair the property, failing to pay taxes and assessments, permitting mechanics liens to be filed. For example, they've had some construction or work done at the premises that they're now unable to pay for, and their contractors might file a mechanics lien. Not satisfying the landlord's obligations under the leases. And now we're getting to some more egregious situations like diverting rent to make distribution to the partners without making the mortgage payments. And then finally, misapplying insurance proceeds. So during this time, if you have non-recourse loans in your portfolio, you should be alert for this kind of technical default or more egregious wrongdoing by borrowers who are commercial property landlords. Okay, back to earth for everybody who doesn't have that type of loan in their portfolio. We'll move to the next slide. And we'll talk about the federal law's credit reporting requirements. The CARES Act amends the Fair Credit Reporting Act. And unlike the forbearance requirements, when we talk about the credit reporting requirements, these requirements are not limited to any particular loan or any particular property type. The amendment applies to a forbearance that has been granted on or after January 31st of 2020. And this amendment to the Fair Credit Reporting Act is effective for 120 days from the law's passage or 120 days from the day the national emergency is terminated. So again, I think Congress could have read this a little more carefully because those words before the comma really are irrelevant because the national emergency has not been terminated, even now 4 days after this law was enacted. So we're talking about 120 days from the eventual day that the national emergency is terminated, that this amendment to the Fair Credit Reporting Act will remain in effect. Let's talk about what the requirements are as we move to the next slide. The credit reporting requirements apply to borrowers who are granted relief due to the COVID-19 pandemic by being allowed to make a partial payment, to skip payments, or to modify the loan. So in those situations, the servicers are to report the obligation as current if it would otherwise be current. So if the borrower today is due for April 1st and you're granting a forbearance and they don't have to make their April or May payments, for example, you are to continue reporting that debt as current. But if the loan was already delinquent, the delinquent status may be maintained. So let's talk hypothetically, the borrower is due for February and March, and now you're granting them a forbearance so they can skip their April and May payments. In that case, you can report the loan as being delinquent. You should continue reporting it as delinquent. But in that hypothetical, let's say they're due for February 1st and March 1st, they're being granted forbearance for April and May. And then let's say May 15th, they deliver 2 payments to you. Those 2 payments will be applied to the February and March payments in our hypothetical, which means the loan would be current except for the payments that are being skipped. That would be the April and the May payments based on the forbearance agreement. And in that hypothetical situation, you would report the loan as being current. The only exception is if the loan has already been charged off. Next slide. Let's dig deeper into forbearance, what it means, and how to employ best practices with your borrowers. When we talk about forbearance, we're talking about short-term relief. So after the financial stress has ended, the borrower will be enabled to make full repayment through sustainable terms. So sometimes forbearance will mean they skip a payment or 2 or more, and those payments get moved to the back end of the loan, which will extend the maturity date. Other agreements might call for skipping or reducing the payments and then catching up gradually once the forbearance period ends. Or there could be a variety of programs that you might have to help your borrowers. But we're talking about short-term relief to minimize the long-term impact on both the borrower and the lender, and we want to minimize the risk of foreclosure. Next slide. First and foremost, you should establish a company-wide policy at the forefront to comply with the legislation, the federal law, and any other state laws or other governmental orders that might apply. It should be a clear company-wide policy, but yet still considering borrowers' individual circumstances. If you have a collector's incentive program, let's say they get a bonus based on their collections, will that lead to a conflict of interest when a borrower asks for a forbearance? So collectors with that kind of incentive program might be more reluctant to permit the borrower to enter into a forbearance agreement, which could be in conflict with your company's policy. So review that situation so you don't have that kind of conflict of interest. In cases where you do have discretion, not the federally backed mortgages where the CARES Act applies, but any other kind of loan where you do have discretion, consider, has this borrower been granted prior extensions, or have they defaulted in the past? Have you had past forbearance agreements with them? Are they already on a payment plan? Or is the loan soon to mature, or maybe it even has already matured? And these are some factors you should take into account in establishing your policy. You should review the borrower's situation to determine whether their financial stress is short or long-term. Some may be on furlough and will be back to work hopefully when this COVID-19 pandemic emergency is terminated, but others might not be employable anymore for various reasons and have a long-term situation that you should take into account. If you have 2 borrowers on one loan, are they both under the hardship? And are they receiving unemployment benefits so at least they have some income? Next slide. What if they paid ahead previously? Consider whether you might have or enter into an agreement to draw down on previous overpayments to make the payments. in lieu of a forbearance plan, allowing them to skip payments. That's a possibility. Again, your policy should provide for what happens to the payments during the period. Are they skipped? Are they reduced? Are they required to make interest-only payments? Your policy should be clear in that regard. Will the payments be deferred or reduced payments move to the back end of the loan, which will extend the loan's maturity? Will you capitalize the missed amount? But again, not for a federally backed loan. Remember, you can't charge interest on the skipped payments if it's a federally backed loan under the CARES Act. Or will you be able to enter into a sustainable repayment plan after the forbearance terminates? Also, your policy should cover what happens to your negative escrow items, advances for real estate taxes or hazard insurance premiums, or even for protection of the property. How will those negative escrow amounts be dealt with during the forbearance? Move to the next slide, please. Be mindful of the Consumer Financial Protection Bureau's regulations that have been in existence for years already. Make sure that you promptly acknowledge the receipt of a loss mitigation application and make a determination whether the application is complete, and process those requests promptly. You're going to be experiencing a wave of these requests. I don't know that the CFPB will enforce these particular requirements strictly, but they are on the books, and knowing the CFPB, I wouldn't count on them to be generous. Next slide. What are the best practices for lenders' forbearance agreements? Now, when you made your loan originally, you did your due diligence. You had your borrower provide an application with their personal information. You had your borrower provide documentation to show their income and expenses so that you could determine that the borrower qualified for the loan. And for a second reason, although you hope and expect that the borrower will fulfill all the terms of the loan and pay as agreed through the life of the loan, but you know that a percentage will default. You'll end up in litigation or in foreclosure. And so the documentation that you obtained at the outset is helpful to us, your collection attorney or your creditor's rights attorney, in making a recovery quicker and more effectively. So when you receive a forbearance request, now is a good time to also use some due diligence. Again, not for federally backed loans where you're required to grant the forbearance, but for those loans where you do have discretion. Number one, does the borrower qualify based on your policies? So what documentation should you request in order to be able to trust the borrower that they are truly experiencing a financial hardship, and for what period of time? And secondly, now's the time to update their personal and financial information that you obtained at the outset. So they may have a new residence, they may have different financial circumstances. Now's the time to get their employment information that might be updated so that that will be usable, whether it's 1 year or 5 years from now. Hopefully never, but at some point in the future, if they do default, you'll have good information that will help us, your collection attorney, to make the recovery promptly and more effectively. Next slide. You should know that an oral agreement is enforceable, but you should have a policy that requires your collectors to not make any oral agreements. a written signed agreement will always help avoid misunderstandings. An oral agreement can result in difficulties, both in your relationship, but also if it comes to litigation later. You should review other loss mitigation options available to the borrower. So forbearance might be appropriate for many borrowers in today's environment, but not for every borrower. Some borrowers might never be able to fulfill all the terms of the loan, let alone the forbearance agreement. So you might discuss other loss mitigation options available to them at this time and decide what is the best option for that particular borrower. You should review the agreement with your borrower. Most importantly, make sure your borrower understands that a forbearance delays but does not forgive the obligation to make the payments. Make sure that your forbearance agreement is signed by each borrower if you've got more than one borrower on the loan. And just as a side comment, I think it's a good idea to take this opportunity to warn the borrower about scam artists. So just like you and I are working all day long trying to deal with the situation, how are we going to make recoveries? How are we going to stay afloat even? We're working very hard, but the scam artists are out there working even harder, trying to come up with schemes to take advantage of your borrowers. And if they're successful, your borrowers are never going to be able to make their payments. So I would give the borrower a warning so that they're alert for scam artists who might contact them as well. Next slide. Let's talk about the provisions of the forbearance agreement itself. First, the lender, when they grant the forbearance agreement, unless they're required to do so under the federal law, but the lender is giving the borrower an accommodation that they're not otherwise required to give. It is not unreasonable to require the borrower to make certain acknowledgments and some waivers as part of the forbearance agreement. So number one is your forbearance agreement should contain an acknowledgement and a reaffirmation of the loan documents so that maybe years from now, if we end up in a foreclosure action, the borrower can't raise as a defense that they didn't execute the documents, for example, or something like that. They should also acknowledge, as of today's date, the date of the forbearance agreement or the effective date of the forbearance agreement, acknowledge the balance due, including unpaid principal and interest, late charges, other charges, and any negative escrow amount, so that they cannot make an argument in a future lawsuit that the balance from prior to the forbearance agreement was not what the lender says it was. If the borrower is already in default, the forbearance agreement should contain an admission of the existing default. Not that you're going to act on it because you're granting the forbearance, but the forbearance agreement should contain an admission of a default if they are in default, so that if we end up in litigation later, we already have an admission of the default and we don't have to deal with that issue in that litigation. Next slide. Those were some recitals, and now we'll talk about the actual terms of the agreement. How long will the forbearance period last? Is it one payment, two payments, three payments? It should be well defined. As I said earlier, what happens to those deferred or reduced payments? Are they moved to the back end of the loan? Will there be some kind of repayment program after the forbearance period ends, and so forth? Especially for longer forbearance periods, you can require the borrower to provide periodic financial updates, especially for commercial borrowers. If you're granting a longer forbearance, you should ask for periodic financial updates. Your forbearance agreement should contain a requirement that the borrower is to provide further documents to confirm or carry out the provisions and intent of the agreement. Now, what I'm getting at here is we deal with foreclosure cases where we find that the mortgage was defectively executed in the first place, or there's some issue in the documents that will give us trouble and could even defeat a foreclosure case. By including this kind of term, the borrower will be required to execute new documents if necessary to cure those defects, so that in a future case we won't be stuck with a difficult situation. Your forbearance agreement should also contain a term allowing you to immediately terminate the agreement upon the expiration of the forbearance agreement or the borrower's default. So if your forbearance provides for reduced payments as opposed to skipped payments, and they fail to pay even the reduced payment amount, you will be entitled to terminate the agreement at that time. Or if there's a different kind of default, mainly in commercial type loans, but also in residential loans, there are other requirements such as keeping the real estate taxes current, maintaining the property, maintaining paid up property insurance. If there's a different kind of default, that could also be a default that can trigger the termination of the agreement if you, the lender, chooses to. Next slide. Some additional terms to continue to include in your forbearance agreement. A waiver of defenses, set-offs, or counterclaims that the borrower may have from past causes of action. So again, if you're granting this accommodation to your borrower, it is not unfair to have your borrower waive any past defenses that they might have in the event you end up in litigation in the future. Now, they're not waiving anything that might happen going forward, but to ask them to waive any defenses or claims they may have based on past activities is reasonable. You might have some cases where the loan was in default and you've already issued a demand letter, a notice of default that might be required by your loan documents. In some states, there's a state statute requiring that kind of notice of default. Ohio doesn't have that kind of state statute, but for example, Pennsylvania does. But anyway, if you have already issued a notice of default, your forbearance agreement, if you're granting one now, should contain the borrower's acknowledgement that you did provide a demand letter or a notice of default in accordance with the loan documents, so that when the forbearance period ends, if they remain in default, you won't have to start all over and you can take action without having to send a new demand letter or having an issue raised in litigation as to whether that initial demand letter was actually sent or not. Your forbearance agreement should contain an acknowledgement that the borrower has had the opportunity to consult with an attorney. So that's a fairly standard term that we like to include in any agreements or contracts with borrowers. And finally, an acknowledgement that the agreement is binding upon the parties, their respective successors, assigns, heirs, and personal representatives. Not to sound morbid, but you could have a borrower who, because of COVID-19, might not last, and you might be dealing with their heirs when the time comes. Next slide. Now that you've entered into a forbearance agreement, what should be done? My recommendations are monitor the fulfillment of reduced payment requirements. So if your forbearance agreement requires reduced payments, make sure that they're actually making those payments, especially for longer forbearance periods. I think it's a good idea to periodically communicate with the borrower and review that they remain obligated to repay the amount of the unpaid principal and any unpaid interest, their option, the borrower's option to terminate or shorten the forbearance if circumstances are improved. Even the federal law contains a provision that the borrower may terminate or shorten the forbearance period. So if you've got a longer forbearance period, maybe the borrower is back to work before the forbearance period ends, and maybe they can start making payments at that time, which is really in the borrower's best interest to stay on track at that point. And as the forbearance expiration date approaches, communicate with your borrower so they realize that that day is coming and their payments will resume. Next slide. Just a word about title insurance. If you have a loan policy of title insurance, you should have a loan policy of title insurance for any purchase money mortgage in particular, and even for other kinds of mortgage loans as well. But if you have a loan policy of title insurance and you're going to have an extended forbearance agreement, I recommend that you contact the title insurer to ask the title insurer to confirm that the coverage will continue. I think it should continue. I think it will continue. I think the title insurer will agree that it continues, but I think it's a good idea just to touch base to confirm that the title insurer agrees that it will continue. Now, 6 months is an arbitrary date. I think it's a good date as a rule of thumb for forbearances that are going beyond that time to contact the title insurer. And we'll get to our last slide now. Actually, it's our second last slide. I'm asked this question often: should a forbearance agreement be recorded? Well, let's answer that question by understanding why should any real estate document be recorded. Deeds are recorded, for example, to put third parties on notice that the buyer, the grantee of that deed, now owns the property. So a third party who is dealing with the seller should be on notice that if that seller wants to give the third party a second deed, that second deed is not going to be effective because the deed that's already on the public record is notice to everyone that it's there. Mortgages are recorded to put future lien holders on notice of the mortgage's lien priority. A mortgage is actually effective as between the borrower and the lender, even if it's not recorded, but you should always record a mortgage so that a subsequent lender will be on notice that you've got your mortgage and it's on the record, and that that subsequent mortgage loan or subordinate loan will be subordinate to your mortgage's lien priority. Loan modification agreements, there are some that actually increase the interest rate. Many decrease the interest rate, but those that increase the interest rate or advance new money should be recorded so that, again, a subsequent lender will be on notice of the full extent of your mortgage's lien priority. Those are deeds, mortgages, and some loan modification agreements. But when it comes to a forbearance agreement that simply allows a skipped or reduced payment, I see no reason to record that forbearance agreement. You're not at risk of losing any priority to a subsequent lender, and why incur a recording fee when there's really no benefit to recording the forbearance agreement? Let's go to the next slide. And finally, bankruptcy. As we all know, when a borrower files bankruptcy, it creates an automatic stay. So at that point, you are prohibited from communicating with your borrower in an attempt to collect the debt. And we, as your collection attorney, are prohibited from filing a lawsuit to try to collect the debt. But you should know that if a loan was previously discharged in a Chapter 7 bankruptcy, don't worry about your forbearance agreement creating personal liability. That loan has been discharged. The forbearance agreement will not create personal liability, but it will allow the borrower to have the benefit of the forbearance agreement to avoid the fear of a foreclosure. And conversely, if the loan was reaffirmed in a prior bankruptcy, the forbearance agreement will not affect the loan's reaffirmed status. Okay, let's go to our closing. And we'll take a look and see if there are any questions. Again, I just want to repeat that these slides will be available to everyone, so you will be receiving those. And again, if you have questions, you can type them in the panel on the right. So one question that has been asked, do federally backed loans include SBA loans? SBA loans are not specifically stated in the federal law. I don't want to give a definitive answer, though, because they are clearly federally related, but they're not specifically in the definition. So that's a question I will have to look into a little more deeply. And if the person who asked that question wants to send me an email, I'll be happy to follow up on that for you. Okay, here's another question. The question reads, can you do 90 or do you have to do 180 days? Again, I'll say it, this will be the 10th time. The federal law only applies to federally related loans that are defined in the Act as federally related. The law provides for those loans, the borrower may request up to 180 days. If the borrower requests 60 days, you must grant 60 days. If the borrower requests 90 days, you must grant 90 days. If the borrower requests 180 days, you must grant 180 days. But only for federally backed loans that are covered by the federal statute. Any other kind of loan are not subject to those requirements, and you're free to impose or grant whatever forbearance period you desire. It could be 30 days, it could be 60 days, whatever your policy and the individual circumstances provide for, you can grant. The next question I see is, please clarify interest accrual on federally backed mortgages. Is the interest rate moved to zero, or is amortized interest calculation acceptable? Interest may not accrue on the missed payments or on the reduced payments during the forbearance period on a federally backed mortgage loan. So that means zero on those particular payments. Again, as I said, if you move those payments to the back end of the loan, you're going to have to find a way to prevent interest accruing for the forbearance period on those particular payments. And once again, only for federally backed mortgage loans. I believe that's our final question for the day. So this concludes our webinar. You're free to contact me if you have any questions. Again, the slides will be made available to you. I welcome your calls or emails, and please stay safe and have a good day.